I'm joined by Harry Littman from the Talking Feds YouTube channel and the Talking Feds podcast. Make sure you subscribe to both. Judge Tanya Chutkan, federal judge in Washington, D.C. We haven't heard her name recently, but we'll be hearing about it right now after the Supreme Court made that horrific immunity decision where they found that Donald Trump or people in the highest office in our land could essentially order SEAL Team 6 to kill their political opponents. And as long as it's an official act, or as long as it's within the core presidential functions, they can do it and apparently get away with it. And if it's part of the core functions or official acts, as an evidentiary matter, you can't even bring up that stuff. Even if the conduct involves private conduct, you can't bring official conduct in proceedings involving private conduct. So the Washington, D.C. case is all about the insurrection. It's all about Trump's attempt to overthrow the results of a free and fair election. Judge Chutkan had this thing ready to go for trial. That's where Donald Trump made the argument for absolute immunity. He lost there originally. It went up to the D.C. Circuit. There was a Republican and Democrats on that panel. Trump lost there. Then it went to the Supreme Court, and we all know the rest is history there. So now the question is, what happens before Judge Tanya Chutkan, Harry? Are we going to see, though, mini trials, if you will, evidentiary hearings where Judge Chutkan's going to have to call in witnesses now and have these kind of mini pre-trials to determine, is this official? Is it not official? Does she have a sufficient record ahead of her already? If she tries to hold the evidentiary hearings, does Trump object and say, can't hold the evidentiary hearings because of prong 3 of the Supreme Court's test, which is you can't even introduce evidence if it potentially has a tinge of official conduct? So how does Judge Chutkan even hold a hearing if every item is objectionable in the first place? It's clear that the Supreme Court didn't just grant Trump what he wanted. They went above and put poison pills throughout it to really make it unmanageable, unless you have a way to unpack it, Harry.
So on the contrary, you have really nailed it, Ben, in a way that people have not fully appreciated. They have this already breathtaking holding, completely making the president a king, but then they include these mines and sinkholes that really totally complicate the terrain. She already, a lot of their guidance was very slippery. Who the hell knows? They serve it up to her and give some hints. And remember, we are in immunity, and Trump's going to fight everything, meaning whatever she rules, he'll get an interlocutory appeal on, and then possibly even the Supreme Court. They've created this little, rule for one, so they can just sit there and, swat it down, between doing cert petitions. And look, your point is on the money. There's a lot of enthusiasm or hope for this idea of a mini trial. At least the American people will see the evidence. We'll see Mike Pence called to the stand. We'll see Mark Meadows called to the stand. They'll have to testify, and even if it's not the same as a criminal trial, you'll nevertheless get the words. You'll hear it. It'll be driven home and have the kind of impact of showing that Trump, at a minimum, did terrible things that were not official. But I think that there's traps for the unwary there, just as you say. So check it out. Jack Smith, Your Honor, we want to have an evidentiary hearing. We call Mike Pence, and we want him to take the stand and tell us about the conversation. So then you can decide, Your Honor, was this official or unofficial? Donald Trump or his lawyer, Emma, will jump up and say, you can't do that. The Supreme Court has said that you're not allowed to use any immune conduct to prove even an unofficial act, which would be a crime. And you call Pence and ask him questions, that's immune conduct. You can't use it. So now, wait a second. What comes first? We now have this circularity problem, but they're going to say, Chutkan, Judge Honorable Chutkin, you can look at the allegations in the complaint, but no evidentiary hearing, because the very things you want to use for the evidence are what the court has said you can't use for evidence. And now we are stuck. All right. What happens? Chutkin could well say that, boy, that really makes a nonsense of an already difficult opinion. I'm going to go ahead. Let's have the evidentiary hearing. Call your witness, Jack Smith. But I think, given the context at that point, Trump jumps up and down and tries and takes an interlocutory appeal. And I think he'll probably be able to. In other words, what everyone wants now as the very second best thing to a trial that the Supreme Court already has defeated by slow walking this from December to July is a mini evidentiary hearing. Good friends and colleagues of ours have brought it up in the New York Times. This seems, at least some way of officially giving the word to the American people of how pernicious this was. But I think the courts, both saying you can't think about motive, but also here, you can't even listen to evidence. I think they've given Trump a lot of grist for the mill to say, sorry, you can't do this evidentiary hearing. And at a minimum, I think it gums up the works enough for a delay. Maybe even the Supreme Court seems to have unbounded zeal for his immunity. Maybe they, if the district court or court of appeals disagree with him, they say, no, that's right. Do it on the papers. You can't have the evidentiary hearing. So I think, just as you say, more than the actual holding, but the sort of traps and mines for the unwary are going to make it really hard for people are not fully appreciating they've given him not just a get out of jail free card, but a whole friggin' deck to play. And all he's got to do is try to play those cards either successfully or enough to forge a delay through November. I'm not confident that an evidentiary hearing can even take place.
I think
glum news, Fred. What can I tell you?
Well, we got to deliver the facts, as they are. And I think that, the one, to the extent there was a defect in any of the analysis leading up to any of this, is that the Supreme Court was going to say that the very foundation of our democracy doesn't exist. I think in some of the most extreme circumstances, you thought the Supreme Court might say, you know what? Like in the worst case, remand it for evidentiary hearing on certain issues, and let's determine which conduct is outside of core functions. And then Jack Smith can argue, look, this was campaigning, like the Blasingame decision. This was in his, he was seeking this for personal gain. Elections are clearly outside of the province of Article 2. That to me was, if you were thinking an extreme take of the Supreme Court, they were going to punt it back, cause the delay, and do that. But for the Supreme Court to say there's absolute immunity for core functions, absolute immunity for official acts, and there needs to be a strong presumption that anything the president does is an official act that gets that absolute immunity to begin with. So you start with that strong presumption. And then 3, as an evidentiary matter, nothing can come in. Even if you get through the threshold, you show that it's a private act, you show all of that as a matter of evidence, it can't come in if it relates to the official acts that you'd have absolute immunity for. And that's the part that I think that they were spending all of this time. The Supreme Court was trying to fashion something that would totally, in one fell swoop, try to kill all of the existing cases in a raw political power play to help Donald Trump and hold the pendulum in a way that the American people, don't agree with.
Yeah, so, look, it's a sophisticated surmise on your part, Ben, because remember, Barrett dissents on just this point. So it could have been that they were really working it out. She said, come on, why, what are you saying? You can't even introduce evidence. And really, what are they saying? Their general principle is you need a vigorous, aggressive, whatever. It's not even constitutional. It's just their idea of good government. But what does that have to do? Why will a president not do something because she or he would think that down the line it would be public? I mean, official actions do tend to be public. So that was just a total, extra stretch, as was this friggin' nutty idea that you can't consider motive, which is the SEAL Team 6, the whole difference between what we think makes him so pernicious and what presidents can do and should do. I do want to say I was never myself there people have been talking about this evidentiary hearing idea from before. I did not sign on to this, and I worried that in fact I didn't anticipate, what's the great Monty Python line? Nobody anticipates the Spanish Inquisition, but I didn't anticipate this crazy ass exclusion of evidence idea. But I did think they might say you decided on the allegations. In other words, I did think they wouldn't want to give the power to a district court. They would want to keep it a pure legal question that they would have total final authority on. And they not only did that, but they took this extra step. It's a disaster, not just at the core, but in many different concentric circles. And, we're not talking about other cases now. Maybe we'll do that later. But I just want to say there's just hardly a case that a prosecutor could conceive of that they haven't given Trump at least the means to foist off and stall for months and months. And what's that mean? That means, forget about maybe. This is my view. I know, maybe I'll be proven wrong, but forget about some kind of official sanction of, aha, he did it. New York says so, or aha, he did it. Judge Chutkan says so. It's to the American electorate, and that's kind of it. It's really, really, really sobering.
I want to do another video with you where I've been thinking about something that I think President Biden and I think all presidents should do. It may merely be symbolic, but I think it is something that could be done. And I'll tease it here, and then you and I will do a whole other hot take on it later in the week. Can a president issue an executive order, even if it's symbolic, declaring a waiver of any possible absolute immunity provided under the ruling? You put it in an executive order. I hereby declare that I will follow my view of the Constitution, which is no one is above the law, and declare a full and total waiver of the decision as it applies to me. And, whether or not you can actually have a waiver or not, I think it sends a powerful message. And I think then it should be asked of Trump or other people who in the future want to hold it, will you support that executive order until there's a constitutional change that needs to be made? So I've been thinking about that.
Hey, that's our next hot take. That's a great idea. I look forward to discussing that.
All right. Make sure everybody you subscribe to the Talking Feds YouTube channel. It's free to subscribe. They're on their way now to 300,000 subscribers. Let's keep growing pro-democracy, detailed legal analysis channels like that. Go check it out. Talking Feds YouTube. Have a great one.
Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.